Hello folks, welcome once again to the Supreme Court Historian YouTube channel, and in this video we will continue to make our way towards the A.K. Gopalan judgment. This video will be dedicated to some background information about the case. How did this case come up at all? And before talking about the facts of the case, we need to spend some time about that to get a better understanding of what this was all about. What this was basically all about is preventive detention, something that we have looked at a couple of videos ago. And this concept of preventive detention has been in place in India for a while. It was originated under British rule, of course, and some of the more well-known preventive detention statutes historically were the Defense of India Act of 1919 and of 1939. Those two enactments, as you can see, were during the World Wars, during the First and the Second World War, and the government saw it fit to provide for preventive rather than punitive detention of certain individuals in case officers of the government believed that freedom would be abused by that individual and would somehow be a threat to national security. That was further made serious in the 1944 ordinance passed by the Governor General, Restriction and Detention Ordinance. Having said that, I have named this slide ambivalence towards preventive detention. I should actually call it omnivalence towards preventive detention, because there were occasions when these such enactments were repealed and then again enacted. So the Government of India Act 1935, as you might be aware, provided for elections to provincial assemblies. Provinces was the name given to what we today know as states. And after elections were held under the Government of India Act 1935, several provincial governments that were basically Congress governments came into power in various provinces 1937 onwards. And these Congress governments, pre-independence provincial Congress governments, repealed many preventive detention enactments. As you would expect, most of the ministers of those Congress governments had been arrested under preventive detention provisions sometime or the other. So it was but natural that they would repeal them as soon as they got the opportunity. It was also an opportunity for them to demonstrate to the people of India what kind of government independent India would have, assuming that those Congress ministers would be there at the time of independence, would be there in power then. Despite that, as soon as independence was gained and even while the constitution was being enacted, provincial governments, again led by the Congress party, ended up enacting public order and public safety laws which provided for preventive detention. We are talking about the period between 15th August 1947 and 26th January 1950, when the British were not in power, were no longer holding the reins of power. Hence my use of the term ambivalence towards preventive detention. There were reasons, of course, for provincial Congress governments or state Congress governments to reenact preventive detention laws during this period. This was, of course, the period after partition, and also when there was a threat of communist insurrection. But communists were not the only ones who were being detained under these preventive detention acts. Hence the ambivalence could really be called omnivalence, because it was quite pervasive. Communists were a major recipient of the attention of the preventive detention acts at that time, and while lists of communists were being made, it turned out that several socialists were also being arrested along with that. The example that I've given is during the Calcutta rail strike of 1949. Having said that, apart from communists, Hindu Mahasabha and Rashtriya Swayamsevak Sangh members were also being detained, especially after the assassination of Mahatma Gandhi, because these two organizations were accused of having connections uh, to that particular tragedy. Their members were also being detained. So this was, you might say, equality in play. It was not towards any particular political party or ideology. Communists as well as right-wing members were being detained under the Preventive Detention Enactments between 1947 and 1950. The number disclosed by the government much later in the day was that in 1950 there were 10,000 people detained under some preventive detention enactment or the other. So that is quite obviously a very high number. Remember once again that these were people who were detained preventively and not punitively. They had not committed an offense, they were not being punished for having done something, but they were being uh, detained under the pretext of being stopped from doing something. That is, of course, the irony of preventive detention. All of this, of course, was going to be regulated by Article 22 of the new Constitution, which provided every individual the right to be informed of the grounds under which they had been detained, the right to approach legal representation, the right to be heard by an advisory board within 3 months of their detention, and so on and so forth. But once again, Article 22, a fundamental right, it is in Part 3 of the Constitution, did not abolish preventive detention. The only right that was granted by this article was that if you were detained under some preventive detention law, then you would have the right to be informed of the grounds under which you were being detained. You had the right to counsel. You had the right to be to get advice from the advisory board. So it was not exactly a very fundamental right, was it? Further, all of this would be the situation unless you were detained under a particular preventive detention law enacted by Parliament or somebody. This seems hard to believe, so I have pasted Article 22. Clause 1, no person shall be detained without being informed as soon as may be the grounds for such arrest, and defended and consulted a legal practitioner, and every person detained shall be produced before the nearest magistrate within 24 hours. And then comes clause 3. Clause 1 and 2 do not apply to enemy aliens and to any person arrested or detained under any law providing for preventive detention, which means that as long as you have been detained under a law enacted by Parliament or by any other state legislature, then those first two clauses about being informed of the grounds, etc., and about approaching a magistrate within 24 hours, those two grounds did not apply, no longer applied. This kind of irony existed right from the enforcement of the Constitution. However, it did not prevent the lapse of the pre-constitutional laws. There were several people under arrest, as I mentioned, for example, RSS, Hindu Mahasabha and Communist Party members under arrest or under detention anywhere between 1947 and 1950. And to prevent the lapse of such pre-constitutional laws, on the very day of the enforcement of the Constitution of India, on Republic Day itself, the President of India issued the Preventive Detention Extension of Duration Order as per the powers given to the President under Article 373, which I have pasted there. You may pause the video to have a look at that particular article. So what this particular presidential order did was that it extended the functioning of the legislations beyond the date of the enforcement of the Constitution. These laws would have lapsed as soon as the Constitution came into force, but this presidential order extended their duration for 1 year as provided by Article 373. However, that was not enough as far as the government was concerned. If the government believed that this extension order by the president would suffice, they were in for a rude shock, because the high courts came to the rescue of the detainees. That particular presidential order, the Preventive Detention Extension of Duration Order 1950, was declared unconstitutional by several high courts. I have pasted the footnote that appears in Granville Austin's Working a Democratic Constitution, page 56, footnote number 62. You can see this you can view Austin's book online at archive.org. That is where I have taken this screen print from. Archive.org allows you to borrow the book for 1 hour, I think, if I remember correctly. So anyway, that is the list of high courts which found the presidential order, Preventive Detention Extension of Duration Order 1950, to be unconstitutional. Article 226 of the Constitution allows all of us to approach our specific particular high court in case we have been detained seeking a writ for habeas corpus. And Brahmeshwar Prasad, Sunil Kumar Bose, Prahlad Jena and Shaukatun Missa Begum, all of these approached their respective high courts, Bihar, Bengal, Orissa and Hyderabad, seeking habeas corpus, and they were granted habeas corpus, and in turn each of these high courts held that particular preventive detention extension order to be unconstitutional, to be violative of Article 21. So then the stage was set for a showdown between the government and the judiciary, and it led us down the path to the Preventive Detention Act of 1950. This particular enactment was required because of these preceding events. There was a need for a central legislation because high courts had begun releasing detainees under state enactments as well. Not only had several high courts found the presidential order to be unconstitutional, but there had been several state enactments, as I had mentioned in the earlier slide over here. Public order and public safety laws by provincial governments, 1947 to 1950 are the ones that I'm talking about. So those state enactments had also been found by the High Court to be unconstitutional and to be criticized by the High Courts, who had now begun releasing people who were detained under those state enactments. So the remedy sought by the government was a central legislation. There was another operational problem, let's call it, which was coming up pretty quickly. 26th February 1950, exactly a month into our republic, several communist detainees in Calcutta would have to be released because 3 months would have been up for them. This 3 months, we are talking about clause 4 of Article 22 of the Constitution. We have already looked at the previous 3 clauses in a previous slide. Article 22 clause 4 says that the preventive detention shall not be longer than 3 months unless an advisory board has reported before the expiration of the said period of 3 months that such a detention can be extended. So the detainees in this particular case, they would have to be released because there was no way that an advisory board could be constituted before that 26th Feb date, and then the facts of the cases for each of them would be brought before them, and then for each of those detainees, that particular advisory board would then have to report that indeed the detention needed to be extended. All of that would not have been possible, and Article 22 clause 7 required all of that to happen, clause 4 rather. So on 24th Feb, 2 days before that deadline for those communist detainees, the full cabinet and the Attorney General, Mr. M.C. Setalvad, approved this preventive detention bill, and the next day, 25th February, a special session was held of the parliament. 25th February happened to be Saturday. Parliament at that time, of course, happened to be what used to be the Constituent Assembly. So it was a single house. It was a unicameral parliament for those few months between 26th Jan 1950 and the first Lok Sabha elections that we had. So all of this meant that this rush towards a preventive detention bill was taken up by the government, and on this special Saturday session on 25th Feb 1950, the Preventive Detention Act was unanimously passed by the Parliament of India, and it was under this 1950 Preventive Detention Act that Mr. A.K. Gopalan was arrested. What was special about this Preventive Detention Act of 1950? Unsurprisingly, it did provide that the grounds of arrest should be disclosed, unless disclosing those grounds was against public interest. Who decides whether it was against public interest? That was not specified. The enactment also provided for an advisory board of 2 individuals qualified to be judges of high courts, and that advisory board would decide whether sufficient cause for that detention existed, and if it existed, whether it could be extended beyond the 3 months. But there would be no recourse to an advisory board for up to 12 months and not up to 3 months if that person had been detained for being a threat to the defense and security of India, for a threat to the relations of India with some foreign power, or for grounds of security of a state, not security of the state, but security of any state, any of the provinces that existed at that time, or if the detention had been on the grounds of maintenance of public order. Let me clarify once again. You had to be presented before an advisory board within 3 months if you had been detained under even the Preventive Detention Act of 1950, unless you had been detained under one of these grounds, in which case you had to be presented before an advisory board within 12 months. So detention up to 1 year, especially for those Calcutta communists who would be whose 3 months would have been up on that day, they would still be detained for up to 9 months beyond this date. So that was the legislative trick that the government of India managed to pull off. And of course, it was this Preventive Detention Act under which Mr. A.K. Gopalan was detained rather, and it was this Preventive Detention Act of 1950 which was challenged by him. That is the background of the A.K. Gopalan case. It's been our longest video so far, and I hope that it has been helpful. Now onwards, the next few videos, we will look at the actual case. We will look at the facts of the case, the arguments presented by the opposing counsel, and finally the judgment given by the Supreme Court of India and analysis of that particular judgment. That is the agenda for the next few videos. Hope you join me then. Thank you.